none, we'll do a vote. Um, okay, so Commissioner Coleman,
Aye.
Commissioner Rodriguez,
Aye.
and I approve also. So that's 3 approvals for the June meeting minutes. Next we have the July meeting minutes. So I believe the two of us, Commissioner Coleman and I will be able to hearing none, we'll go through the votes. Commissioner Coleman,
Aye.
Commissioner Rodriguez,
Abstain.
and I approve. So we have 2 of the 3 people who were present approving, so that those minutes are approved as well. Okay. Moving on to public and welcome co-chair Adam. Thanks for being here. Well, we are not yet broadcasting. There's been some time. We are. Hey. So we are here and broadcasting now. So welcome to those of you who are with you online. Sorry for the delay. So far, we've just covered the roll call, agenda review, and minutes from the last meeting. We have a section for public comment. I do not believe anybody is here to provide public comment, unless one of our members of the division will. Okay. All right, so we'll move directly into old business. Updates here very briefly. So both the gunshot detection system, GPO, and the unmanned aerial system have been approved and are being operationalized. The update for our gunshot detection system, and I don't think we have to deal with this right now. It's just an update, and we can ask questions. We can think about how we move forward. Is that the suggestion after we passed this was from the division was to take the name ShotSpotter out because that is a brand specific thing, and they were saying, you know, if that changes for a different system, then it would say ShotSpotter. And so we said we can't just change that without a vote. I'm not sure it's a priority for us to go back and change it while they still have the system, but we can talk about that. I don't know what you all think. The important that is while they still have ShotSpotter. The next contract is coming up. You know when that's like the end of this year and the end of next year, I believe, is the sound thinking contract. Yeah. So my sense is that we don't have to deal with it right away, given our other priorities. The CPO is in place, and you know that was the main goal here. Any other thoughts?
So it's we've already passed it. It's in place, and we just have to change that one term throughout the policy.
That's kind of the ask for the video.
Okay. Yeah, I would leave that up to you wanting to put it in the agenda. Low hanging fruit.
Yeah,
I wouldn't.
sure.
I'd be comfortable. Moving.
Okay. So let's see how things go, and like if we want to put it in the next agenda, we'll take a look at that. Or if not, we'll just set our priorities. The other update is for the drone GPO. There is now, and I should share this, or maybe Alex can share this. There is now a public-facing website that shows the flight path as required in the GPO, and that was just went public yesterday, I believe. And you can set it up so you get alerts when it happens, when they post something new there, and I will share that out to commissioners or somebody will share it out so that we know it's there, and so the community knows that that's up and running. So, in my knowledge, they have not yet started using the drones, but that is fully operational item, so they could start using them at some point in the near future. Any questions about that?
That's a great update. Thanks.
Yeah. All right. Any other old business that we've missed that you all want to talk about? Okay. new business / work session. So the goal here is with these four, if we get to the point where we feel we can vote, great. If not, this will hopefully be a third discussion to get us closer to that. And the first one on the agenda is 1.07.06, the corrective action guidance. So some history here, we have done a lot of work on this last summer, actually. We had a former police officer and a former commissioner and another community member who worked on this and sort of did a big revision of it. And then we went through a process. We approved it as a full CPC, and then it went through, and we got DOJ and monitoring team comments back, I believe, in January. Commissioner Benito and I met in April and incorporated those changes. And the copy that you have before you has those changes in it. There are a lot of notes back. Looking at this now, there aren't comments, but you can see, of course, we don't have color. Well, yeah, I don't know that you can actually see where the changes are. But just know, I mean, not that this means we have to approve it or anything, but just know that that has been, there's been a pretty thorough process. Lieutenant DePente and I met just before this meeting to get some newer input from the division. And so what we could do is start to have a conversation, kind of go through it in a way that makes sense to you all. I think it might be good to hear his comments and ideas, and then you all incorporate it, give you a chance to look through it as we discuss, and then we can give us, it'll be essentially that document as we, with his note, as we move forward to the next meeting, maybe we can.
Who are you referencing?
Lieutenant DePente.
Got it.
Yeah. So he was assigned by the policy unit or whoever, PC Schlatt. But yeah, you could go up. Yeah, that would be good. That would be good. That way you don't have to. Yeah. Just talk through your comments, and it'll give us a chance to speak if we're on the same page. If we have questions as we go through, and then we can take these comments and then have a deeper discussion at our next meeting. So, yeah, so for those of you, yeah, I mean, this basically has a discipline matrix that, or it used to be called a discipline policy. It's now the corrective action policy. And it has, the usual, it has definitions and the levels of discipline, 4 levels of discipline, or corrective action. I'm sorry, I'm a bit, sort of winging it here, but I feel like we had a pretty good discussion. We can just sort of.
I can go through
that again.
I guess sort of page by page.
Yeah.
This is my first opportunity to see this was when I got here today, so it was a quick. I didn't have the opportunity to do a deep dive. There's some super minor edits like capitalization of the word division, the first paragraph of page 2. But I'll stick probably to the more important things. We mentioned on page 3 in the group 3 violation, the last phrase there involves any conduct that constitutes failure to adhere to any contractual condition of employment or requirement of certification mandated by law. That should be in the group 4, and in fact, it is in the group 4. It's the red light's on. The green light's on. Is this better? Oh, I'm sorry. So that it's in the group 4 violation. I don't think it belongs. It was moved to the group 4, but they left it in group 3. I don't think it's appropriate in group 3. So it's something to look at to maybe strike from there.
Yeah, it's essentially the same exact language as in both. Actually, if you look at group 4 definition below, it has pretty much the same language. So his suggestion is to keep that in group 4 and delete it from group 3. On page 3 is definition of a group 3 violation. There's language, the very last, after the semicolon, involves any conduct that constitutes a failure here. that is the same exact language as in group 4 definition. And his proposal is that we strike it from group 3 and leave it in group 4.
That's all for that page. On page 4, under letter of reinstruction, it's missing that the safety director can also issue a letter of reinstruction. It just says the chief of police. It also says that I recommended the word remedial be switched to just retraining instead of remedial training. A little bit of a negative connotation with remedial. But at any rate, it says that these remedial or retraining records shall be retained in the training section and the personnel unit. I would ask that it would just be in the training section. We've stopped duplicating records across the division. Training section keeps training stuff, medically unit keeps medical stuff, my unit keeps discipline. Okay, so they're just so that we're duplicating work. Moving all the way up to page 7 on non-discipline violations, we have, I had a little concern with discourteous or rudeness to supervisors in order to ensure a good chain of command. That one, I don't know if that should be a non-discipline violation. That's something to be looked at, I think.
You're talking about that whole section of this?
Just as it applies, discourteous rudeness to supervisors.
I still don't see it. Page 7?
Yeah, I'm sorry, on page 7, it's in the non-disciplined one, it's the third one down. And it's just the supervisor part.
Oh, okay, got it. Or, okay.
It's a non-disciplined one,
Under rudeness. Okay.
right, to ensure, proper chain of command and discipline. And then we talked about, in the group 1 violations, about 2/3 down, you'll see a failure to search prisoners for weapons. And then on the next page, in the group 2 violations, about quarter of the way down, you'll see failure to search arrestee for contraband. And those two things are awfully similar, and I would almost venture to say that not finding weapons is more dangerous than not finding contraband, and any weapon once it entered a prison would be contraband anyways. I was just a failure to search arrestees or prisoners. It doesn't matter why you fail to search them. If you fail to search them, that should be the violation. And then, make it whatever you guys think is best out of the group 1 or group 2. But it's appearing in both, and I don't see the rationale for it being defined in those two ways.
It seems to me that it should be a group 2 violation as well.
And just say then, yeah, you make it a group 2, and then just failure to search arrestees or prisoners.
And this might be a question for you, Commissioner Van Leer. Do we know where the bullet points originally came from for the group 1 and group 2?
So they've gone through a process. They were originally written by, former police sergeant and Commissioner Richard Jackson and another community member. And then they've gone through DOJ process.
Okay.
So I can't tell you exactly each one. I mean,
Where
I could look through a lot of this.
Nope, don't worry about it.
Yeah, it's just it's been a
Thank you.
process. So,
Also in the group 2 violations, there's the fourth bullet point down, knowingly engaged in revoked secondary employment. I mean, you're knowingly disobeying an order from the safety director there. I would think that might be a more serious violation. It's revoked. It's not that it wasn't authorized or not approved. It was actually revoked, which is a little bit different than forgetting to fill out your paperwork. That's the fourth bullet point under the group 2 violations.
and the fact that it's knowingly, obviously.
Knowingly, and that it was revoked.
Yeah.
like I said, it's not a matter of just being unauthorized secondary employment, which happens sometimes. It lapses, you forget to reapply or something. Okay, into the group 3 violation. About 2/3 of the way down, there's 2 bullet points. The first one I'm concerned with says knowingly mishandled or improperly prepared for criminal case. To me, those are 2 completely different things. To knowingly mishandle something is completely separate from being improperly prepared. Improperly prepared can be any one of a number of things. That's very vague, and simply, I don't believe it belongs in a group 3 violation. It could be you were supposed to pick up 4 pieces of property maybe for the case, and you only picked up 3 accidentally or something to that effect. That it's too vague with it. Like I said, it's just too vague with improperly prepared, and I don't think it belongs in the group 3. I don't have a problem with the knowingly mishandled. That's a whole separate issue, and I agree with that. But the 2 of those things put together in 1 bullet point, I think, is inappropriate.
You had also talked about the improperly prepared being pretty vague. And
Right,
yeah.
what
Yeah.
does that sort of mean? Like I said, it could be, like I said, you picked up the wrong property. Maybe you misread the case number you had that day and brought the wrong file or something. I don't know, it could be something fairly innocent. A lot of our detectives are pretty swamped, and I hate for,
Yeah, so we have to think, maybe, obviously, we want people to be as prepared as possible in these situations, some of them more important than others, but we'll have to think about how that gets defined. It seems like it's a challenging thing to define because it's so big.
it's pretty vague, and maybe due to its vagueness, I would knock it down a group probably. If it was something that was an innocent mistake, as opposed to, like I said, the knowingly mishandled, which is a whole separate
I
issue.
actually read the knowingly as applying to both. Like, so you knowingly either mishandled or improperly prepared.
That's a good point.
So if
Unless is knowingly mishandled
Then
something you all, like, what that means.
right, but I
separately?
would say then put the knowingly in both spots just to make it clear, so there's no confusion on that. Because somebody could read that, well, he improperly handled the case. It's right,
Agreed.
okay. Yeah, I'm fine with it then, for sure. Okay, and then right beneath it is unauthorized or knowingly improper vehicle pursuit. As we were talking earlier, a pursuit isn't authorized until many seconds of information goes over radio. You have to give your location, the reason for the pursuit, what the vehicle you're pursuing is, possibly the license plate, if you could read it, number of occupants, weather, traffic, all these things. The supervisor's gathering all this information. That pursuit isn't technically authorized yet. Eventually he'll say, okay to pursue or terminate that pursuit. So that's different from knowingly improper vehicle pursuit, where you're doing something like you're not calling it over radio. You're chasing this car, you're not calling it out, or the pursuit was terminated and you're still doing it anyways. You're not taking the first opportunity to reverse direction, slow down and reverse direction. That's different from unauthorized. So I'm just concerned about that unauthorized word there.
Commissioner Coleman, I'm asking you because you've been working with me, so I don't know if that.
Yeah,
that
so
works as-
so to me, I think is the confusion unauthorized indicates not having a higher level of authority saying okay versus that starting this pursuit is in violation of the policy.
So, like I said, if you're calling up everything there, let's just put like an unauthorized where this that results in a serious bodily injury. You begin calling off the reason for the pursuit, and immediately this car, goes through a light, T-bones somebody, and causes serious physical harm. You just started to give the location and that this car was taking an aggravated robbery, and boom, it just happened that fast. It would be, I don't know that it would be an authorized pursuit yet. Nobody authorized it yet. It was, I might be, can you,
So the lieutenant's right, and it's often misunderstood that.
Can you grab a mic? There's a handheld mic. You can grab that. Because I think it's important. Thank you.
You just hold down the red button.
It's often misunderstood that in the division that patrol officers or officers that are about to initiate a pursuit must receive permission first, just like the lieutenant was saying. The policy as it stands now does not require that. So unauthorized I definitely understand what you mean by that, but for us in a paramilitary organization, authorized means your supervisor saying you can do this. So it just might be a good idea to look at those words.
Yeah, I agree, because I'm not sure that was the intent behind, that's, you know what I mean? So I would clear that up too,
Yes, we need to
the unauthorized.
spend some time figuring out how we,
And maybe, and to the officer's points, there could be some language. I think one of the concerns is, okay, it gets terminated midway. If we want to call out after something has truly been unauthorized, then I think we could just expressly say that.
and I would say they would be knowingly improper at that. You would clearly be knowingly.
I was just going to use the
improper.
word knowingly too.
yeah.
Right.
Is knowingly improper, will that cover unauthorized, like specifically, you're not authorized, should we say knowingly improper and or unauthorized, or is that too much? Is knowingly improper sufficient to cover? I guess it's all like, the authorization has to happen, otherwise it's gonna be improper, right?
Sergeant Graham said knowingly engaging in an unauthorized pursuit.
As opposed to the use of improper, or parsing language here, but.
Yeah. Unauthorized. Just to, Lieutenant DePente's example of how he just said the patrol officer is giving information and the car crashes. I was just before leaving for this meeting, I was reviewing a pursuit investigation where that exact scenario happened. So, and it happens a lot. They're giving out this information, the sergeant's accepting it, trying to determine if this is something he will allow to continue, and the pursuit will crash, or they'll stop and run before they can even get that permission. So it does happen. It actually happens a lot.
So knowingly does cover that then. It has to be knowingly.
Yeah.
I think it would cover both.
Okay.
Because when they first initiated, they knowingly thought they were doing something proper, then it gets terminated. If the officer hears that and it comes through and if they knowingly continue, that would be an issue. But if something happens where they did not get that to stop, I don't think, you know what I mean? That would not be fair for an officer to be in violation if the authorization didn't come through.
Yeah, I think that's sort of settled. And like when we were talking earlier, there's a lot of things, as you mentioned, for the supervisor to start considering. He's envisioning in his head the location where this is at. Is there school in session? What time of day is it? What's the weather like? All these things he has to consider. What was the nature of the crime? And then he's going to make a decision whether to authorize the pursuit to continue or to terminate the pursuit.
So I guess for me, it's two separate things. One is improper. You haven't received the necessary supervision authority. But unauthorized can mean that you are pursuing more than you should. So how do we account for that in this instance as well? Because I understand you're seeking permission, but depending on the scenario, of course, when there's vehicle pursuits, residents might, unfortunately flee. However, there are instances where if they see a police officer pursuing them, that will increase that. And especially if you haven't received the proper permission, I think the idea is to really reduce these incidents.
They are able to initiate a vehicular pursuit without, like, they don't have to have their permission. So if they're within the policy, they can initiate. And then I think the issue with authorization is that call in where the supervisor terminates it.
But
So especially because of the authorization, like, I guess I see it in, so this is step one, everybody can get stuff. Step two is. So I guess the way I see it is that when you pursue a chase, there are like steps in place. And that you're not going for force, especially if you haven't received that permission.
So I don't want to call it a pursuit before the authorization from the supervisor because it's not a vehicle, per our definition, it's not a vehicular pursuit yet. Okay, so when we're behind a car and we're calling out, we're asking for that permission to pursue. So I don't want to have that confusion. We're not pursuing it. And if the supervisor say, no, the criteria doesn't meet, no, so the officers are not going to turn the lights and sirens on and go. So they wouldn't even start the pursuit at that point.
But there is common understanding and language and understanding, because if it's not, then for me, that's unauthorized.
I'm sorry, say that one more time.
So, like you stated, that you're not in pursuit yet, right? That there should be certain things that you are allowed to do in that stage of pursuing, right? The pursuit, right? So I guess it's common knowledge and understanding. And if that is violated, to me, then it's unauthorized.
Yes.
I'll just read it right from the GPO so that we have a very clear understanding of it. It says that under procedures, section 1, officers may initiate a vehicle pursuit when all of the following criteria are met. A, the suspect operating the vehicle refuses to stop at the officer's direction and flees apprehension for an actual or alleged 1, violent felony, or 2, operating a vehicle intoxicated, OVI. So those two things have to be in place first. Anything outside of that would be an unauthorized pursuit. So, for example, chasing for a misdemeanor, that's not an OVI.
Mhm. And I had been reading that to mean if those two things were in place, you could initiate a pursuit, but it sounds like I'm wrong on that. You still have to get permission. Got it. Is that okay? So should that be clarified then in the draft since we're working on it? Or do the officers just they know that?
So even if those things are met, you
Uh-huh.
still are asking permission. So you're going to go over the air, give all that information, and then the supervisor is still going to say yes or no. And then if the supervisor says yes, they have procedures in the policy that they have to follow too. So
Okay, so
Yeah.
what I'm missing is it's just not in the pursuit realm yet. The initiation criteria have been met, and that initiation, a part of that is I'm calling the supervisor for the permission. Then it's
Yes.
authorized. Now you are technically in a vehicular pursuit. Okay,
Mhm.
thank you.
because it
That's
might
so
be
helpful.
a violent felony and all those
Okay.
things, but then it might be schools letting out. So yes, you met that part, but you didn't meet. It's not safe to do it at this time. So it varies.
Just one last thing on this before I let it go, I guess. If you, if they engaged in a pursuit, then it wasn't, if they started, like to chase a car, and it didn't fit one of those two criteria, they'd already be knowingly involved in improper pursuit. If they were chasing, if they took off after somebody who just had a minor traffic violation or something like that, it would clearly be a knowingly improper pursuit because you didn't hit those criteria of what is required of, So, that's all I have for.
No, that confuses me. 'Cause
Okay,
that's just the initiation phase. So what if you knowingly know that it's a misdemeanor? You call it in. What if you get authorization?
You would never get authorization to pursue for a misdemeanor. It's absolutely forbidden. 100%. No pursuits for misdemeanors outside of OVI.
So then should we just put knowingly, improperly initiate or engage in?
That
just to
sounds fine to
cover-
me. Yeah, that sounds fantastic.
So the reason that confused me is because we established that until there's authorization, you are technically not in a vehicular pursuit. This only says vehicular pursuit. So in order to catch knowingly initiating improperly, I guess to me, that is not captured here.
So I thought it was covered that it actually is it is the initiation of a pursuit if you have a violent felon and they're refusing to stop. I think you are engaged in
Well,
pursuit, we're calling it out.
The pursuit policy is under revision,
Okay.
so I wouldn't put exactly, maybe
Okay,
just
fair.
like,
Fair.
improperly following pursuit procedures, because it could change.
Yeah,
Something like that.
yeah. But good catch. I think it should be, you should not be able to knowingly not
Yes.
initiate either. Both should be covered. So I think that's just, a matter of getting the right language.
All right. Moving on to page 9. And now I'm, unfortunately, or fortunately, I don't know, defer to Sergeant Kindness because it's excessive physical force not within policy is defined at a group 3. And my issue with this I brought up is maybe using a level 2 use of force or a level 1 use of force when de minimis would have been appropriate. That use of force would be considered excessive, yet it's still fairly minor to be in the group 3 range. And to lump all excessive use of physical force into as group 3s, I didn't think was appropriate because we have different levels of force that we use. And so, for instance, if you're using level 3 force when you should be using de minimis, that would certainly seem to be a group 3 violation. But if you used maybe a level 1 use of force when you should have used de minimis, that seems an inappropriately harsh penalty. I didn't start to throw you in on this like this, but
Hello, everybody. Can you hear me?
Oh, go ahead.
I think some of the factors in there that we look at, especially when it comes to Force Review Board, is the size, skill level of the officer compared to the subject. And that doesn't really come into play here when we see that 110-pound female officer is trying to use level 3 force on a 280-pound subject. This doesn't really factor that in there. So that's where I can see it should be adjusted, where sometimes level 3 use of force would be appropriate for a level 1 situation, so to speak.
Okay.
None of the ranges in here really speak to the size, the skill of the officer or the situation that they're in.
So is the overall edit here that this part should essentially be based on the level of force used, and that determines what type of violation it is?
I don't think I understand.
So we need to parse out which force violations occur to determine if it's a group 3 versus a group 4. Like, are we just saying they shouldn't all blanketly be in one group? It should be based on the actual level of the violation.
okay, I just agree that all excessive force.
9, the first bullet. What about the mitigating?
Do we talk about those? Do we talk about mitigating factors? I am. Where's the
I'm always looking at it. I'll sort of explain like my point of view. He's much more of clearly of an expert on it than I am, but maybe an officer used level 1 force, which is fairly minor. But we have de minimis, which is just escorting a person. And in review of it later on, it was determined, he probably shouldn't have used level 1 force. De minimis would have been sufficient. to then lump that in a group 3 violation, I think would be inappropriate for, use of force that on a judgment call, someone looking at it later on saying, yeah, it looks like it, should have been a different level when it's pretty close. It's you're not purposely trying to cause pain or harm or something like that to the person. You just use force slightly outside of policy, as opposed to way outside of policy, like, taking a handcuffed person and then beating them with your baton.
Yeah, I think.
So,
One question is like, we're looking at group 4 violations here, right? So right now that excessive physical force not within policy is.
Oh,
listed in
Group 4.
I'm sorry, group 4. I said group 3 or
Yeah,
group
that's okay.
4.
I just want to make sure.
And so I think we are saying the same thing. What I'm hearing is, say de minimis was available and should have been the force used, but you use level 1. That could be maybe a group 2, group 3. But if de minimis was available and that should have been the force, but you use a level 3, that might be a group 4.
Right.
That okay.
Maybe possibly, right? You're
Like
right.
it should be based on the egregiousness of.
Yes, yeah. I forgot we're in group 4, which is termination, and it could be, you on a questionable call, you use I'm talking like slightly more, and somebody looking at it later on saying, this is more of a training thing almost than discipline.
Agreed.
I think that the entire incident should be fully investigated and reviewed. We say should or should not. There should be a lot of articulation from the officer of why they used what they did, why they worked outside of training, why they worked outside of policy. And if they can clearly articulate why they felt the need to use the higher level of force for that situation, I think that should be a fairly mitigating factor when it comes down to discipline. In a full investigation, and we don't have that response from the officer, we don't have the knowledge of why they went to that level, then maybe look to group 4.
Okay,
Yeah,
so
I agree.
yeah,
I
we
agree.
need to,
That's a
I agree,
change for
especially
sure.
since it's group 4 is termination. So we need to find some ways to
Yeah.
spread that through the different.
I don't think you can make a hard decision that this specific
Right.
move or technique or level of force is automatically a level 4.
What would
Without-
be helpful for us is if in the coming days you could sort of look at it and talk amongst yourselves and send us some language that in categories that would make sense, that would meet the needs and the nuance of situations, the need for investigation and understanding versus us trying to make something up. I think it would be good to get some ideas from you and then we can discuss that. If that's, don't you want to say it right now? I mean, it just seems like a little bit more complicated with different levels.
Or we could tie it directly to the excessive force policy, I guess, and just only remove, use of force.
Yeah, I guess we can look at the use of force policy. It just, if there is like,
That's the thing of how would we distinguish it? That's something we'd have to meet out. It seems like it's
Yeah.
sort of a complex thing to do, but to put it just in group 4 is I think, is
Yeah.
completely inappropriate.
Can I point out one other thing? If we're using force, it doesn't really match the situation. This goes to a prosecutor. That officer's then charged with a crime because it becomes assault. If it should be de minimis force, for example, and I come in there and I use the maximus force just for word's sake, that's going to go to a prosecutor, and that officer is going to be seeing criminal charges. So that would be group 4 where it goes to termination. If our complete review with our use of force assessment and the internal affairs investigation and case prep, it comes through that it's just retraining is necessary and it's not a crime, and the prosecutor rules over it and says there's no criminal conduct here, then why would it be a group 4?
okay. Yeah, we just need to have, I mean, we don't want to take it out of the different levels of violation, but we want to have something that makes sense. So we'll have to work on language that makes
Because I
sense.
believe all 2s and 3s are going to the prosecutor for prosecutor review, aren't they?
I don't know. That'd be internal affairs. I don't know.
Commander? All the ones internal affairs, do they all go before the prosecutor for review for charges, criminal charges? And once they're criminally cleared, then we look at departmental issues.
could we tie it to, since the investigation occurs when the force is used, could we tie it to the determination decision? Like after the use of force?
You could say something similar to a sustained violation of this specific section of a use of force policy.
Exactly where I'm going. I like that. Yep.
Mr. Coleman, can you clarify your last question? Because are you asking if whether it's excessive or not is determined by the results of the investigation? That's what makes sense.
So, yeah, well, ultimately, I'm trying to figure out what language could be used to not blankedly have all uses of physical force a group 4. I think a sustained violation at a high level of, or a sustained violation of actual excessive, is different from using, I think would capture the seriousness intended in the bullet point.
And then my other question, thanks for the clarity. Mike, do we define excessive anywhere here?
It would be, I guess, an analysis of, not in the matrix, but an analysis of the use of force policy. And then when you violate within that, then it's excessive.
Right. I mean, okay, I was just wondering if maybe, I mean, I know it's not an easy thing to do, but I think, I think one of the goals of this policy was to make it as less subjective
Fair,
as possible.
yeah.
And so I'm thinking, it's not easy, but if we could somehow, like, I think I like the example that was used by the officers where, if someone, should have done a lesser level of force and there's something like a group 1, then that should not be put in this category. I think my concern with using these investigations, and this is just, I know we're just discussing, is I think sometimes maybe we may not agree with the results of the investigation. So I don't know. I think I wouldn't use that per se. I think we can talk about it, but my opinion would be that I would be cautious with using the results of the investigation, because looking at some of the investigations that we have in our possession, we don't always agree with the determination.
Well, I guess my response would just be, so this is not, we're not implementing it. So if there was a investigation, it's sustained, and then it comes to us because we disagree with it, then we would have final say to overturn that. But I guess we don't really have a say at that level of the discipline that's going to be enacted after that investigation. We just have to review it after the fact. So I don't know.
The term excessive force is a media term, it's a core term, and it's not really what we look at. When we look at uses of force, I'm a use of force expert, I do investigations on them. We look at it whether they're objectively reasonable or not, whether the actions were appropriate for the situation or not. We don't try to use that term excessive force because that becomes very subjective to who's looking at it and who's viewing it. So we try to just determine if it was objectively reasonable for the situation at hand. Was it necessary? Was it proportional to what the subject was doing? And then that's how we determine whether or not the officer's actions were appropriate. So might be a better term to use would be objectively reasonable.
Thank you for that. Oh, go ahead.
I was just gonna say the use of force policy under general 2.01.03 F, it says the unreasonable use of force shall subject officers to the disciplinary process, possible criminal prosecution, and or possible civil liability. So in that policy, they're using unreasonable use of force.
I like it.
Continue, Lieutenant. Keep moving.
Yes. Okay, so moving down into the ranges of corrective action, and we're almost done here. And the group 1 violation, it says that it runs from a letter of reinstruction to a 2-day suspension without pay. And then it goes on to say there shall be no consideration of aggravating or mitigating circumstances for group one violations. I think any violation should have context placed on it. What was going on at the time? What's the overall picture when assessing something? So I'm gonna just say, I disagree with that no consideration of aggravating or mitigating circumstances for when you're talking about something from a letter of reinstruction to a 2-day suspension. And then there's the typo that you fixed probably, right?
Yeah, and I know that this issue of the aggravating mitigating for the group one violations we've been discussing it, so we'll have to like take that into consideration and
What-
look back at previous. I don't remember offhand like where that's from, but there were very clear reasons why we did it this way. But we'll have to look at that and we'll take a deep dive into that.
To the chair, what was the rationale behind, not considering aggravating or mitigating circumstances, do you know?
This is what I just don't remember like all the, I have to go look at notes and sort of figure that out, but we have to do a deep dive into that and make sure we're, okay.
And the final comment I have is on page 10, under procedure B. That whole section should be moved down a couple of paragraphs. No, I'm sorry. I guess that part's right. It's right underneath the second paragraph. So the hearing officer will review the facts and evidence presented during the pre-disciplinary hearing and determine a finding of guilt or not guilty. We discussed this. The hearing officer doesn't do that. The chief or the public safety director does. So just moving that first part down to the last paragraph of B, and says we're in cases where the chief of police or chief director of public safety is not the hearing officer, then they'll make a recommendation to it. So it's kind of broken up and goofy the way it is, and just cleaning that up by moving that part down below and getting rid of the hearing officer determining a finding of guilt or not guilty.
So we
take it out.
We discussed this before, and it seems like in that second paragraph in B, that starts with the hearing officer review the facts, starting after pre-disciplinary hearing, removing and determine a finding of guilt, because that is really up to the chief of police or the chief director of public safety. And it actually says that below, that they will make the final determination, but that the hearing officer will make a recommendation. Right? You can see in that fourth paragraph, 2 paragraphs down, in cases where the chief of police or chief director of public safety is not the hearing officer, then the hearing officer will make a recommendation to those 2 people for a final determination. I think it is kind of confusing this way, because it's not the hearing officer who makes that determination. It is in the end the chief or the director of public safety.
So we can just delete that.
one.
Yeah.
Yeah. Because the rest of the language is there below, really. It already said that. No,
Yeah,
just
the second
half of it.
paragraph of B, yeah. Oh, wait,
The second half of it, yeah, second half of it would delete and determine a finding of guilty or not guilty based on the preponderance of the evidence standard. And we could include some of that language, finding it, it might make sense for us to move some of that language down, as Lieutenant Penty was saying, the final determination of guilty or not guilty based on preponderance of evidence standard and the imposition of corrective action. We can do something like that. But anyways, we have to clean that up, because the way it is right now, it's not making sense. Does that make it clear for y'all? Okay, is that it, Lieutenant?
Yeah, that's it. That's all I had. I only had a chance to review it.
Yeah,
It's
well, I
starting about
appreciate
4:45, so.
your quick work here. And again, if in the next few days you keep reviewing and you see other things, please do let us know, because we're going to be over the next month. Our next meeting, which is the second Wednesday of September, we will most likely take this back up for a vote. So, we'll make sure that, DC Schlot gets that. So if people need to be here, whoever needs to be here can be here for that. But hopefully by then we'll have buttoned it down a bit and, be ready for that movement. So, all right, any questions or further discussion from the committee members who around this or next step? So- Okay. Well, thank you again. Yes, appreciate it. All right. Automatic license plate reader. Let me open my copy up. So you should have, just for clarity, yeah, if you want to step up. Um, and I'm so sorry, but I've had too many meetings past few days. We met with you on Monday morning, Commissioner Benito and I. Yeah.
Hello? All right, there we go. Hi. So I'm Lieutenant Mateo. I'm the lieutenant over the technology section for the division. We met, as he was saying, we met on Monday and we went over some of this. I did find a couple of things that I had questions about that I wanted to cover with you.
And I think you both should have the copy that was sent out on Monday with some of these, with these updates. So hopefully it's in there, but we can talk through that. Yeah, we can just, I think we started with the definitions. We had some questions early on about the hot list. And we came up with, the actual terminology being vehicle list. And I think that was one of the first things on one of the definitions on page 2. We talked about vehicle lists and then in parentheses, hot files or hot lists, because there's different ways of referring to it. The hot list, I think, is more the terminology used by the officers who are on the road. But then hot files and something, whatever.
Yeah, that's used in NCIC definition.
Right.
Yeah. The hot list is kind of like jargon that all law enforcement agencies use. But if you look at it through the NCIC leads, they use hot file. So
you wanted to go by the official term of vehicle list, but then make sure it's clear to people who are doing the work what that means. And in that same definition under vehicle list, we had talked about who enters this stuff and where this stuff comes from, where the information, I shouldn't say stuff, where the data come from, the list of license plates. And so we've worked on language there that says vehicles of interest for investigative and or enforcement purposes entered by the division, provided by other law enforcement agencies or compiled from NCIC, the National Crime Information Center, and the Law Enforcement Agency Data System. So it's those two systems are in use, and those are the ways that vehicles get on the vehicle list, correct?
Correct.
Questions? We'll keep moving. Under procedures, administration operation, that's page. What page is that? Page 2. We again have vehicle lists, NCIC, and leads in the second paragraph. All entries and updates of specific vehicle lists within the ALPR system not originating from NCIC and leads shall be documented by the requesting member and approved by a lieutenant before initial entry within the system. So before that, it said, I think it said RTCC, and there are problems with that in terms of depending on their staffing and the time of day. So we had talked about this, I think, in the previous meeting about thinking that lieutenant. That was the language that came up the last time when we discussed this. Does that cover accurately, Lieutenant?
Yep. Yeah, but there's one part in here that we'll get to that I just want to kind of fix because it does talk about how a detective can make entries.
Right.
So I just want to make sure that we address that, because here it says lieutenant, and then on the other side
Right.
it says detective, so.
Yeah, that's a good flag. We'll get there.
Yep.
Any questions so far? Okay. All right, authorized uses. Number one, I think we did add some language here around court orders, locate vehicles or license plates associated with court orders or active police investigations of felonies or escalating misdemeanors. So that language around felonies and escalating misdemeanors is new and more precise, we think. Lieutenant Mateo, do you want to provide any context with that?
Yeah, for the authorized uses.
Yeah,
I think we were talking about how the department uses it in the sense of, we basically just use it for part one crimes. So I think the concern, and keep me honest, but the concern was that we're looking at traffic violations and people that have tickets and other things. And you've got to understand that these LPR hits are happening constantly. So we're constantly getting the hits within the car. Most of them are going unanswered. The ones that go answered are your part one crimes, so your felonies, things that are of a higher crime nature. So the authorized uses, when these LPRs come through, I think one of the discussions we had was that basically it really revolves around escalating misdemeanors and felonies. Escalating misdemeanors includes like domestic violences, there's some sexual offenses like GSIs and stuff like that for gross sexual imposition, things like that, that could also be considered an escalating misdemeanor. So the compromise there was just basically to go with the escalating misdemeanors and the felonies when these ALPR hits happen. Now, the one concern or one thing that happened with that also was that we have courts that tell us, right, like court orders, CFC, that comes through, and basically those could be for misdemeanors. Okay, but that's a court order. That's a contempt of court telling us that we have to go. So those would supersede the escalating misdemeanor or felony when in fact ordered by a judge.
so yeah, that's why we added court orders. Any questions about this? Okay. Moving down, on page 3, number 8. Members shall upload ALPR kits that result in arrest or incident report to the designated storage in accordance with division procedures. And I think before we had named a platform, and it felt like it made sense, and kind of like what's happening with ShotSpotter or Sound Thinking, to not name it because it could change, and then this would be out of date. Whereas we say the designated storage in accordance with the division procedures, then it's leaves it open to changes in whatever that database or that storage area might be.
Mm. Yeah.
Okay, we keep moving. Where were we? We said it was. Is there anything else that I'm looking down here? I'm not seeing. There's a piece about manual entries entered by detective. Did we? We have some questions there.
Yeah, are you on page 2 or 3? I'm sorry.
I'm still on page 3.
Okay, so at number 2, if we're looking at the same, if the first entry there is number 2 where it says the ALPR operator shall confirm the hit.
Oh, okay.
Is that where you're at or no? If
No,
not,
but
I don't want to jump ahead.
No, I'm not. I went past that. So if you've got something there, let us know.
I do. So when you read this, it says the ALPR operator shall confirm the hit is active by running information through NCIC leads or through communications. Our policies state we have to get confirmation through CCS. So we have to go through. So my recommendation would be to cross out NCIC leads, and here's why. Is that if we have a hit, it originated from NCIC leads, likely. So the NCIC leads hit has already occurred. So us going through CCS to confirm that communications is basically them going the extra step to ensure that we have a confirmed hit. meaning it's a good grand theft motor vehicle, it's a good crime. So by crossing out NCIC leads, I think it makes it a lot clearer to the division members, and it sticks with other policies and how we have it written.
The one question on that is, when, for example, the hit or the information comes from another, I mean, it comes from another law enforcement agency or from the division itself, doesn't it make sense to go to NCIC at least to do anything? Or, I mean, I'm not knowing the system that well, so.
Well, no, that's a great example. So just to even clear this up more, because that's really where this goes. So let's say another agency did put in something into the ALPR, right? We further want to make sure they go through CCS because that way it's documented. And if we need to do a teletype or something like that, to contact that other agency because they want this vehicle, there's some coordination that needs to happen between our two agencies in order to engage in that. And then we would have to ask for permission, and there's other things that go along with it. So CCS is embedded in our policies as far as the communications piece. So we always run through dispatch.
Questions? So the proposal here would be just to delete NCIC, lead or through,
Right.
and then just leave it as running the information through the communications control section as soon as feasible. Okay. All right. So I had already looked at number 8 about not naming the platform.
So the question is if we're just keeping leads and just taking out, my recommendation is take out NCIC leads or through. So if you just cross that whole thing out there and then it flows, if you see what I'm saying? Yep, NCIC, yep, so it's just the CCS, correct.
Right. So is there anything else in that numbers 1 through 9 there, Lieutenant?
None for me.
Okay. Manual entries, is there anything on the second half of page 3 there with manual entry of the vehicle? Because that we had talked about the detective piece.
Yes, I do have something for that whenever the.
Yeah, go ahead.
Okay.
That's good.
So yeah, here it says manual entries of vehicle information shall be entered by a detective. My concern is if you go to the very, the second page, if you go to, it would be the third paragraph there, where it starts with general vehicle list. The second sentence in there says all entries, updates, and specific vehicle lists within the ALPR system not originating from NCIC leads shall be documented by the requesting member and approved by lieutenant. Now, to me, if you look at that manual entries, it says manual entries of vehicles shall be entered by detective. So to me, it just kind of, it's a play on words. The detectives are going to think, well, I have the ability to do it, right? When in fact, it's a lieutenant. Now, where I see this, because me and you talked and I kind of understand it, because the detectives are going to go through the affidavit process to get warrants and all that, and it's going to go through NCIC, and it's going to ultimately make it to our ALPR system through the leads NCIC system. So the detectives are the ones getting the affidavits, getting the warrants, getting all those things. So I understand that because we spoke, but reading it from a 10,000 foot view, taking myself out of it, it looks a little bit confusing from that perspective. So the recommendation would be, if we're gonna keep the detectives as the entry point, it would be for like affidavits and warrants to get into NCIC. Does that make sense? So basically, the detective would follow their workflow. They would get the warrant, which would then get that into NCIC, which would then go into ALPR because it would become a hit.
Would it require approval by the lieutenant before it goes through, or?
Well, that goes through the court's process. So they have to get the affidavit heard by a prosecutor.
Oh, I
The
see.
prosecutor has to then go to a judge. The judge has to sign off on it. Then once we have a good warrant, basically that's when it goes down. And again, I'm gonna talk in workflow here, but it goes into our process, which they do the data entry into OpenFox, which is NCIC.
The language that would clarify this would be entered and manual entries of vehicle information that have gone through the court's process
There you go.
shall be entered by detective.
Yeah, it could be something of that nature, because at least it takes it out of the other aspect, which is on page 2, which is getting a lieutenant, because now there's some differentiation. And a detective would correlate that with, okay, well, I'm just gonna be doing my normal job and getting warrants and doing all that, which causes missing persons and other people to get into the NCIC system. I hope I'm explaining that well enough. I'm trying not to use jargon or anything, so.
And then that second sentence there, additional pertinent vehicle information may be entered into the ALPR system manually. Is that, I mean, does that still make sense with this first, it's connected to the vehicles, that information has gone through a court process. That's,
Yeah, I mean, because here's the thing. So I think that makes a lot of sense, and here's why. Because we can do from a lieutenant's perspective and from a systems perspective, let's say later on, there's another piece of this that was already approved, went through NCIC, that the detective's like, I just got it. I got this information right now. It's a purple car with white stripes, right? We can do a 24-hour entry into our ALPR system for that. And that's what we call the hot list. So we can put it in our hot list to identify that vehicle using our ALPR system. So it does make sense, because if they have additional information and they want it now, let's say, especially in homicides, you could see this happen a lot in homicides where they get information and they need the car now. Go ahead.
So that example you just gave, that was when, that will be when they need the lieutenant to
Yes,
approve it. But the one where they go through the courts, they don't need a
they don't need
lieutenant.
a lieutenant because that already went through the proper, the actual proper source, which is the courts.
So the part that's highlighted, should there be like an accountability section in there, like what lieutenant approved for you to enter it? Maybe a badge number or something, just a thought of who approved you to put it in here.
Yeah, the one question or conversation me and P had on Monday was basically, what if there's not a lieutenant available with RTCC, right? A lieutenant should be able to make that call,
Mhm.
Regardless of their unit location. So yeah, I mean, we could do something like that and just make it very clear that it could be any lieutenant. Does that kind of answer, or did I miss?
No, that's fine.
so are you talking about still under that manual entry system, with the 4 bullets at the A, B, C, D that say what should be entered? You should
Yes.
also the name of the
That
approving
or just a badge number, something is to show what lieutenant approved the entry.
Oh, yeah.
So that'd be like an E and adding. Okay.
And the ALPR system captures that today. So like when we actually put this stuff in there, you actually need to give a reason for the entry, what it's actually tied to, what crime is tied to, and who was the approving authority for it. So ALPR will not allow you to do anything within its system unless there's an accountability source with it. So they need to know that you're doing this for lawful reasons and you're not just, looking things up just to look it up. So it does capture a lot of that today, just by default. So system setting.
Any questions? All right, so moving on, I think we're done with page 3, where C at the bottom is the supervisor responsibilities, about functioning, proper use, maintenance. I don't believe there were any things that came up here. It might be everything that we talked about. I mean, we added a shall. Other than that, I think unless there's something, Lieutenant, that you need to flag in the last 2 pages of this.
No, this looks fine. So the one thing under C, I think it's just a technicality. It says the OIC shall email the RTCC about damage to ALPRs, and that's a depends. It could be mobile support. So if it's the ALPR within the actual vehicle, it's mobile support. If it's any other system like block, our block system, it would be RTCC. Um,
So we just add or mobile
yeah,
sports.
exactly right. Yep.
Is there, I mean, we have RTCC's email address. Do we need one for mobile sports too, or?
Yeah, or we could just use them as a clearinghouse too. We could just, have it all go to RTCC and then they could just figure out who to send it to too. I mean, we could run it
As long as
way.
that works.
Yeah, it works for us. I mean, I don't have a problem with it. They're constantly monitoring their emails and they can get it to the appropriate,
Yeah. Okay. So we
appropriate
can just
email.
leave it as is.
Yep.
Okay. Good question. Any other questions? Go for it.
My question is about, I'm just trying to figure out this visually, logistically, like how these things work. I like looked up an image of them. So are these these license plate readers? Are they like a physical device that's going to be posted in places throughout the city? So that would mean they would be. So would they be like on at all times to constantly collecting data?
So they're both in cars and posted stationary. Every car has one, right?
Exactly. So all the cars that have the actual systems, the Fleet 3s is what they're called,
Yeah.
Axon Fleet 3s that are in the cars. So these are two different systems. So you've got Axon's ALPR that's in the cars, and then you have Flock. And those are the ones exactly as described. So the ones that are on the poles.
Right.
And they're in fixed locations throughout the city, and ultimately those are always on. The cars aren't always on.
Right.
So it's like whenever they are operating and they're logged into, they are collecting information. The cameras through Flock, those are constantly on. As long as there's power to them and there's not a technical issue, they're always on.
Okay, so my next question is, so you have like this hot list that gets created, right? And so you're looking for specific individuals who have done the things or the crimes that are described in this policy. So my question is, what happens to all the data?
After 30 days, it gets purged.
Okay.
So when I
So-
say purge, it's gone. We can't get to it at all. It's gone.
Okay. And are there any scenarios where I'm just trying to get around to the level of surveillance for the public? When we're using these, is the understanding that these will only be used, the data will only be used for people or vehicles that have been flagged on the hot list, or is there a scenario where that data could be used against someone who has not been placed on the hot list?
No, so our system, the way this whole mechanism works is through our NCIC
Okay.
or our manual entry, which we have a reasonable suspicion or even probable cause in some instances. I gave a scenario where a guy was going through a park and with his car. And we were like, it's only a matter of time before he hit somebody. He hit somebody.
Right.
So we immediately put him in there for 24 hours and we ended up getting the car. That's really all we wanted, to get the car off the road, because obviously he's causing some harm to people, right? So this system, basically, it's a passive system. So cars are going by all the time, right? It has to match the criteria in which we're looking for. So if we want a red Dodge Charger, right? And we put that in there, we have to wait for it to come by. And then it comes by, boom, we got a hit. And it says, hey, here's your Dodge Charger. This is where it hit off of. This is the time it is. Now that car's probably gone already, but at least it tells us, hey, he went this way. So if we know he's going to Elyria or to Mentor, we could let them know, hey, a car that's wanted in a homicide, we have reason to believe it's going into your city, right? So in some instances, if it's hitting within our city and it's a homicide or somebody we really want to get off the road because they're a danger to the public, those, obviously officers are going to see those and they're going to act right away. They're going to confirm it. They're going to do what they do best, and they're going to try to get that person out of the public way for them to be either put in prison, wherever they need to go. So yeah, it's a passive system. Does that answer your question? I want to make sure that I'm answering, because your question you're asking is always on like the frequently asked questions. So I know if you're asking, a lot of people have that question.
Right. I think that, I mean, yeah, I think you answered the question. I think I want some clarity for the public. You know, things can take on a life of their own, and all of a sudden you'll have folks out here saying that we're in a surveillance state and you guys are storing data and, you know, so I just wanted to clear that up, because that's what we're discussing the policy.
One thing to make very clear is 30 days, 30 days, 30 days. That thing is constantly purging. And you don't have to take my word for it. You can, look up Flock's information. It's by default. We don't even have a control over it. They default purge everything and we cannot, even as a law enforcement agency, ask for it. We can't subpoena, it's gone. So we have that small window, 30 days, to find the vehicle of interest, and it's because they're on NCIC.
So you won't have the ability to, you can't download anything?
Yeah, we
You
can
do that?
download it once we get it, but we have to do it within that window, within that 30 days. So if we get the good hit on the car, the charger that, I just made up, we can download that and say, yeah, we've got this car. This is the car. We can put it in our evidence.com, which is our digital storage, vehicle there. But if we don't do that, it's gone.
Okay, thank you, I appreciate it.
Yeah. Yeah. It's a good suggestion.
Coach, do you have any questions? Or-
No, you're good.
Okay, any further questions? Do we feel comfortable moving forward with this? I put out that after I make a motion, but. All right, well, I will make a motion with the changes, with the changes as described.
Yeah.
That I move that we approve this GPO, the automatic license plate reader, GPO, 4.06.13 as revised during this meeting.
Second,
Any further questions?
Yeah, these are all straightforward.
Aye.
Okay, so I will call for a vote. Commissioner Coleman,
Aye.
Commissioner Rodriguez,
aye.
and I, Pete Van Leer, agree and say aye. So the motion passes and this is approved. I'm assuming this will be one that goes to the DOJ and the monitoring team, given it must be consent decree related.
That's from Dan.
But we will find out. We will pass that along. All right. Next on the agenda is arrestee restraint transport into revision. And this is complicated by the fact that Mr. Benito was working on this, and I know had a meeting with somebody from the division. I'm not sure who it was. So perhaps you can at least walk us through this. Your discussion with Commissioner. She's not available. She had a medical emergency. You did, okay. So yeah, if you could just come up, you can sit over there or.
Yeah.
And I'm not sure we'll be ready for a vote on this. You can perhaps-
Say wood on, what's
We
his
can at least get up to speed.
public,
Could you introduce yourself, please?
public information officer, Diaz, yeah. Check you out, so we see.
Sergeant Steve Kindness, Cleveland, Municipal Police.
That's fine.
So, yeah, so we've been working on this one for a while, but, I would love to just hear, go through we have a copy before us. That's probably the copy that you and Commissioner Benito discussed.
Yeah. No, okay.
If you could just walk through some of your conversation you had and the points that were raised, and, yeah, that would be great.
Attempted to meet twice. First time, at her office. Got canceled short. Then we were supposed to meet this morning and she gave me a message about the medical issue, so we have never had a discussion.
Oh, okay. All right, well then, I mean, have you had a chance to review it and, okay, so
Is your
we
email
can have a discussion now. We've got time. We have 20 minutes or so.
Okay.
And we'll at least get ourselves, up to speed with your thinking and,
Good, so I'll reach out to Schlott and Diaz and.
One thing that I don't see in here that we discussed while we're putting this policy together is that officers will have constant contact with handcuffed people. handcuffed subjects should not be walking along on their own, some type of that sort. Especially with their balance mitigated with their hands behind their back.
Sounds good.
It doesn't state that in here, but it was discussed in two meetings that we had. And it's our training that once I place them in handcuffs, I have that constant contact. I escort them to the zone car, I escort them from the zone car to the booking, to the hospital, wherever it might be. But I have that constant contact. I don't see that anywhere in this written document.
Where would that fit into? Would it be a separate section or? It would be under transport or? Restraint, yeah,
I think transport speaks to transport in the motor vehicle.
yeah, right,
And I think it would fit better under the restraint section,
right.
the procedures.
Could you put your mic on?
Saying that I think it should be listed immediately. The first thing they should know, once you place a handcuff on somebody, that you need to stay in constant contact with it. Like a 1A or something like that.
Yeah, that sounds great to me. I put it right there.
thinking it should go in the procedures,
Yeah,
applies throughout the entire entirety of the section.
Yeah.
Okay.
so under restraint, procedures, restraint, toward the top. is What you're saying, right?
Yeah, like right where it says restraints and aid, is your handcuff or restraint, you know.
Restrained individuals will be in
Yeah.
constant contact while they're being escorted by the officer.
Somewhere.
I think we need to do something, members shall handcuff all arrestees and maintain constant contact with handcuffed arrestees, then we go to the exceptions separately.
The other issue on here is everybody we handcuff is only handcuffed behind their back.
Yeah, this has come up, I know, yeah.
Yeah, there is no training otherwise, with the exception of pregnant or postpartum individuals. That's its own separate law, not through any general police order. You want me to go into the why of that?
Yeah, I mean, we've had a lot of discussion around this, and I think this is we're looking at the age, age on children under a certain age, elderly or frail. So it would be, and there's issues with persons who are deaf or hard of hearing, and what handcuffing means for their ability to communicate.
So in those
So I know it's
situations-
complicated, so yeah, please.
In those situations, they just shouldn't be handcuffed. We have constant contact. We have escort. Yeah, we do 2 officer escorts.
Okay.
There's the level of safety of handcuffing somebody in the front, how dangerous it is to a police officer. It is horrendous. There are so many situations where the officers have themselves in a bad way, so to speak, because of being handcuffed up front. And a lot of that comes into the fact that when officers arrive on a situation of scene, their anxiety is at their highest, their apprehension, they're scared. The fear is right there. Once they get into that situation, it gets controlled. Their level of anxiety, apprehension, fear settles down. Their parasympathetic nervous system takes over, settles them down. But it's not true for once they've secured that individual who's now handcuffed. Now his apprehension, fear, anxiety all starts to raise. We have more issues with handcuffed individuals at the booking window, at the hospital, at the final place of the jail than we do usually on scene, because of the way apprehension anxiety raises that individual when the exact opposites happen for the officer. They're becoming more calm with the situation because for them, the hardest part of identifying what's going on in that situation and getting the situation secured is now over with. So as they become more complacent with the situation, the suspect's anxiety is raising. There's going to be an issue. It's going to happen later on. We see plenty of times subjects who take their handcuffs from their back and they have hypermobility in their shoulders. They bring it around to the front, and they're going to be the subject we're going to have trouble with. Right now, our training is to immediately stop, notify a supervisor, and to re-handcuff them correctly. And all of our handcuff training is behind the back, palms together, double lock, with a specific amount of gap between the cuffs. But once they've been handcuffed properly, they should stay that way until we're ready to give them up to the facility they're staying at finally, be it the hospital or be it the jail.
So what you're saying basically is, as we've got at least the general idea here is like handcuff all arrestees and maintain constant contact. Exceptions are made for these groups. But toward the end, it says, number 6 right now, or I believe it's number 6.
Persons who
If
we'll
the
do number
individual
6.
from one of these groups presents a clear and serious risk of physical harm. We had said in front, and you're saying that's really not workable from your perspective. It should be in back if they present a clear and serious risk of physical harm.
If they are not a clear and serious risk of harm to the officer themselves, they shouldn't be handcuffed at all.
Regardless of their status or just those exceptions.
For these exceptions here,
Yeah.
if instead of taking off these front cuffed individuals, they just should not be handcuffed. Just have 2 officers perform an escort. We have plenty of escort positions that secure the subject, keep the officer safe, and have that constant contact where they can escort them properly. There never should be a situation though when we're cuffing somebody in the front.
So if you're in one of the exceptions, so you're a child under 13 or a person elderly or frail, if you're not posing a serious risk, you're not handcuffed at all, is that right?
Correct.
And then, but what if you are posing a clear and serious risk? You're just saying they are handcuffed, but to the back, is that what you're saying?
If they're going to pose a serious risk to the officer, they should be handcuffed behind the back if they're going to be handcuffed. But if we're talking about persons very elderly or frail, the officer should be able to control those individuals with just a 2-person escort, a 2-officer escort.
What about like a pregnant person?
Pregnant people should not be handcuffed. They should be placed into those 2-officer escorts. We train that in the academy. There's too high of a risk for injury for the officer or the individual by placing handcuffs in the front.
So if that person was irate and a danger, you guys would just deal with it without the handcuffs.
Correct.
Okay.
As opposed to making a policy where we're handcuffing someone in the front.
Okay.
Front handcuffing should be absolutely banned from all the officers.
So in terms of the 2-officer escort, that's new language, that's very helpful. Does that apply only to, like, the never handcuffed only applies to people who are individual or pregnant or postpartum? Is there these other exceptions, these other children under age 13, elderly, frail?
I think it should fall under all the exceptions.
So that 2-person escort is for all of those?
Yes.
Your suggestion,
If
okay.
they're not handcuffed, it should be 2-officer escort. We would prefer if they're handcuffed, they're still escorted by 2 officers from a training standpoint. 2 officers cannot control a subject who is elderly or frail. I'm going to say they're probably not that frail. So,
And then handcuffing
would come into play. If they're unable to control or handle them with the escorts and the positions that we teach, then they should probably be handcuffed behind their back.
Okay. Okay, that's helpful. We'll take that into consideration. I think, we need to spend some time with both of you. Talk to Commissioner Benito.
Can I ask a question?
Yeah.
I'm looking at the 3 persons who are elderly or frail. Not all elderly people are frail.
Says or.
Okay. Should we just say frail?
It really could.
Well, it could.
I
But
think-
then
I
again,
think
if you're
elderly
95 years old and you're pretty healthy,
I mean, I have
Should
a
we go ahead
friend,
and-
like, I have a friend who's like 76 and he's still like, hands on this roof and does stuff on the top. Dude is like healthier than
My dad's 80 years old, and I would hate to put him in handcuffs.
yeah. I mean, I think, I see what your point is. I would
What I
leave it
like
as is.
about elderly is it just cues you to the category of folks we're trying to get at. Like, so, because the GPOs are what you use out in the field. So if you're in the car, you can quickly see, you know what I mean? Like, have in your mind, oh, elderly, opposed to frail is a bit more, it just.
I agree with you.
I agree that technically it is redundant and not necessary, but I think it does serve a purpose to cue you quickly. Yeah.
No, it's a good question.
No, that makes sense to me. Yeah, that makes sense.
No, it's good point to raise. It's good, always good to have that discussion. Anything else for that top part? Is there other, so starting with, after that part about, should be in back, there's some issues around, the standard procedure. I think a lot of this language came from the GPO that was written by you all, by division. So there's no questions there on page 2, going to transport. If you want, just go to where you need to go. I mean,
I have
whatever you,
no issue with the section on transport.
okay,
From a training standpoint,
yeah.
exactly what we teach.
Supervision, which is page 5 of 6. There was some language that we added, I believe, perhaps last time we discussed this, in section C, section 3C. If an arrestee threatens to harm themselves, the officer shall ask the arrestee if they want to be evaluated at the hospital. If they answer affirmatively, they should be taken to the hospital. So yeah, I don't know if there's anything in section 3 that you have concerns about.
I don't see that section C is necessary. I understand why you'd want to write that in there. Most arrestees do tend to try to get themselves in the hospital rather than go to jail. And all officers are aware that once I take somebody into custody, they're my responsibility. Anything that occurs to them, if they harm themselves, that's my responsibility to prevent that to the best of my ability. That's
Okay. Well, we can take that into consideration. And we were really intentional about that language, so, okay.
Is the fear there that essentially anytime you ask that, they're just gonna say yes, and we're not really getting at the people who are actually suicidal?
that's what I would believe. I would believe, our policies generally get known, our procedures generally get known, and our people we commonly interact with, regular, so to speak, they will always have to go to the hospital every time, which will just tie up resources that are unnecessary for people who actually need the resources out there.
But the alternative is taking them to jail, which isn't necessarily, may not be the right thing either, but.
No, but every jail has a medical staff.
Right. Yeah. Okay, well, we'll take that into consideration.
Could there just be like a mini assessment done if they're identified, like they go to that jail medical staff and get that, some type of assessment done to see if it should be escalated?
But what if it said if the arrestee was harming themselves, not threatening to?
Okay. Yeah, we'll have to discuss this with Commissioner Benito too, because I know that she had some thoughts around this.
Or attempting to harm themselves.
I think, there was also, we had a conversation last time, and I don't think we've done this. This was in the plan, but to pull up the crisis intervention GPO, make sure there are no conflicts. And looking at the distinction, so this did come up last time, distinction between suicidal threats and suicidal harm. So that's something we need to continue to look into. So we'll do that. But this is helpful. Appreciate the input. Is there anything else that you had to add?
No.
Okay,
The constant contact and the handcuffing the front were the two issues.
that's very helpful.
So does this mean the meeting's now off Chandra's plate? And we just
I believe
simply
so,
need to
yeah.
even discuss next?
We
Okay,
can just pull up a draft. I can check in
you
with
got it all down, perfect.
Commissioner Benito. We'll write up a draft. and send it out. And
Thanks for your time. Very helpful.
yeah, thank you so much. All right. Moving on. So weapon clearing traps, that is, I forget what I shared with you all, but I did share it with, I shared it with, Commissioner Mason and Commissioner Chura. And I was doing some searching online and had some questions, and Commissioner Mason had some questions around, why are you removing the magazine while it's holstered? Why is that not done while it's in the trap? The response from the division was very much like, this is a safety issue. It's safer to remove and insert the magazine while it's holstered because your finger's off the trigger and that is the safest way to do it. Commissioner Chura agreed with that assessment. We were offered a demonstration of this if we want to do that. I don't know that we need to vote tonight on this. I feel like it's not an area of expertise for me by any means. And we did get that input from the division and from our members from the commissioners who have been police officers. I don't know. If you have thoughts on that.
My only question was, I was wondering, they can do the demonstration, but do you all have like any like videos or anything that demonstrate how to do it? Yeah, I think that would. Yeah. Yeah. I think we just need to see the visual. Like, I'm not an expert on it.
From unholstering all the way through clearing at the trap.
The GPO talks about, how to use it to clear or charge firearms, right? So it's removing the magazine while holstered, doing that process and putting it into the trap, and then charge it, insert the full magazine into the firearm while holstered. Yeah,
We can get that.
That would be super helpful. That's a great idea. Thank you, Co-Chair. All right, so we'll look forward to that. Okay. Well, that was a lot of work that we got done. So looking ahead, this can be pretty quick, I think. But these, I think, are our priorities, along with, rescue, restraint, corrective action. But, I know this, if Commissioner Coleman, if you can talk about the plans for vehicle pursuits, that would be great.
So Commissioner Benito and I are taking the lead on revising or commenting on the vehicular pursuits policy. We did send out a survey for community feedback that seemed to be maybe like unreliable data. After we looked at all of that, our game plan is to more widely circulate the survey, meet with CDP on this, and then we are also scheduling a meeting with one other person, a member of the community who has given in-depth feedback. Do you remember who that is? I will say, for purposes of the minutes, and I will get it correct on who we met with when we actually meet with the person, someone knowledgeable in this area. We are having a meeting with someone knowledgeable, also CDP, also knowledgeable, and more widely circulating the survey. And then from there, we should hopefully have a more concrete set of revisions that we can come to this committee to discuss. But this one is a hot button issue, very important. And so we want to make sure we are thorough and getting all of the different viewpoints and community feedback from all sides.
Great, thank you for that update. Yeah, a lot of work. Okay, duties of command superior officers. that something, were you still working on that, or like, I don't know where that's at, to be honest.
So it was brought up between a meeting between Alex, John, and I, and it happened just to circulate because from my understanding that was in the status hearing. So I had asked for that information because from my understanding, it didn't go through this committee. So I just looked at it and just, with all due respect, sent my thoughts on it because that's just the type of person I am. But I technically wasn't like, I don't know if it was supposed to come to the committee, or from my understanding, it was it's in process already. So
Was that the performance review you're talking about? or
no,
This is the
that's
duty
the
command bureau,
policy that I sent you,
right?
I sent the email about,
yeah.
and then you had requested it. So if it's regard to that same,
Thought that was performance reviews, but, all right, we'll look into it. We'll figure it out. So. Pursuit investigation team, that's gonna be subsequent to the vehicle pursuits. Wearable camera systems, that's something we worked on some time ago before the new commission, new commissioners came on, and we need to get back to that. So that'll, we'll have to start working on that. I mean, just, I know that, interim executive director Nuruddin has said he would, Alex has said he would help prioritize a lot of the GPOs. I see that Ryan, Walker, our, policy analyst, is back, so hopefully he can start to pitch in. And we'll just, all of these and more, we've got a list of things we need to work on, so. That's all I have at this point. And the other thing from the co-chairs, do you have any questions? Okay. All right, we do have, there is no public comment, no one's here. And so with that, we will adjourn the meeting.
I have a comment.
Oh, you have a comment.
It is so helpful. You all being here is so helpful. I just really thank you so much. I really do. This was a great meeting. I just
Yeah,
wanted to
and
say
that is our goal, like, at least 2 weeks ahead of each meeting to say what we're gonna be working on so that you all know ahead of time and can be here.
Huge help.
And also want to thank, Lieutenant DePenti and Lieutenant Mateo, for coming to those individual meetings. Of course, Sergeant Graham, you're always available, and it's great. And the rest of the policy unit, so. Yeah, we're getting there. But I appreciate all your support. All right, so with that, I will adjourn the meeting. Thank you all.